Law on Banking and Financial Institutions. November 18, 1999. Equity participations by covered entities in the capital of other commercial companies. Chapter 10, Equity participations by covered entities in the capital of other commercial companies. Article 32. For the purposes of this law, holdings shall be regarded as equity participations when they directly or indirectly confer on a covered entity at least 10% of the capital or voting rights of another company. Article 33. A covered entity may hold equity participations, which must at no time exceed either of the following two limits. 1. As regards each equity participation, 15% of the amount of the own funds of a covered entity. 2. As regards total equity participations, 60% of the amount of the own funds of a covered entity. Article 34. The following shall not be subject to the individual and overall limits laid down in Article 33 of this law. 1. Equity participations in industrial, real estate, or commercial undertakings whose activities are linked to the running of a covered entity. 2. Equity participations in banking or financial institutions, with the prior approval of the supervisory authority. 3. Companies engaged in agricultural activities. Article 35. For the purposes of Article 34(2) of this law, the following shall be regarded as banking or financial institutions. 1. Covered entities. 2. Financial companies, including those engaging in the activities referred to in Article 8 of this law. 3. Undertakings engaging in banking or financial operations abroad as their regular business. 4. Insurance companies. Article 36. Whenever a shareholder of a covered entity is a banking or a financial institution, or whenever a covered entity itself has a stake in a banking or a financial institution, the supervisory authority shall require, for the calculation of a covered entity's net worth on which prudential ratios are based, either the deduction of the participations held by the covered entity in other banking or financial institutions, or the prior consolidation of balance sheets of companies of the group whenever relevant upstream, or downstream holdings reach at least 20% of the capital of related companies. Article 37. Any acquisition of holdings by a covered entity in the capital of an industrial or a commercial undertaking registered abroad shall be subject to the prior approval of the supervisory authority. Chapter 11, Establishment abroad or in Cambodia. Article 38. Any acquisition of holdings by a covered entity in the capital of a bank or financial institution abroad, as well as any opening of a branch or representative office abroad, shall be subject to the prior approval of the supervisory authority. Article 39. The opening of a branch in Cambodia by a covered entity shall be subject to the prior approval of the supervisory authority. Acquisitions of holdings by a covered entity in the capital of another covered entity are governed by the provisions of Articles 19 to 27 as well as Articles 33 to 35 of this law. Chapter 12, Supervisory Authority and Regulatory Power. Article 40. The central bank supervises the banking system and its related activities such as the money market, the interbank settlement system, and financial intermediation. To this end the central bank shall 1. Issue licenses and define the licensing process. 2. Prepare and keep up to date a list of licensed banks which shall be published in the Official Gazette of the Kingdom of Cambodia and in the Bulletin of the National Bank of Cambodia. 3. Be empowered to issue regulations for the implementation of this law which authorize the central bank to determine, in particular the a. Amount of minimum capital and the nature of the assets it is backed with. B. Prudential ratios regarding particularly liquidity, solvency, risk diversification, foreign exchange exposure, and market risk exposure. C. Valuation rules for accounting balances. D. Conditions under which participations can be taken and held in the capital of a covered entity or a financial institution. E. Conditions under which participations can be taken and held in the capital of other banking or financial companies. F. Debts which must be regarded as doubtful, and the provisioning thereof, g. The chart of accounts, the related accounting standards, the rules for the consolidation of accounts, and the rules of the disclosure of accounting statements, h. Conditions applicable to the banking and financial operations that may be carried out in their relations with customers, I. Organization of interbank joint services, including the centralization of financial information, risks, and overdue debts. J. Granting of individual, exceptional, and temporary exemptions. K. Requirements and authorization rules concerning modifications in the business name, legal form, capital distribution, management and activities of a covered entity, or of the head office in the case of a branch of a foreign bank. L. Practice of door-to-door selling of banking or financial services. M. After consultation with the covered entity's professional association, the rules governing the operation of a deposit guarantee system. N. And generally speaking, the modalities for enforcing this law in light of the differences concerning the legal form of covered entities, the scope of their network, and the nature of their activities. 4. It publishes all regulations issued by virtue of its authority in the Official Gazette of the Kingdom of Cambodia and in the Bulletin of National Bank of Cambodia. 5. It supervises the banking system through permanent off-site monitoring and periodic on-site examinations of each covered entity. If the need arises, on-site examinations may be extended to a subsidiary of a covered entity or to any other related entities, including shareholders. 6. It organizes or supervises any interbank settlement system. 7. It may require that covered entities, public offices, auditors, and any other individual or legal entity disclose information considered as useful for its mission. 8. And it may, in accordance with the conditions defined in Articles 52 to 54 of this law, take disciplinary action. Article 41. The supervisory authority's duty consists 1. In licensing covered entities to carry out financial and banking operations in Cambodia. 2. In defining and enforcing prudential rules related to the financial structure and management that covered entities must abide by. 3. In supervising, permanently but after the fact, through both off-site and on-site examinations, the financial position and functioning of covered entities. 4. In imposing disciplinary sanctions against covered entities failing to comply with law and regulations. 5. In referring to the courts if failure to observe laws and regulations undermines the public interest. Managers and shareholders of the covered entities are accountable for errors of strategy, for mistakes in and errors of management, and for deficiencies in internal control, in accordance with the provisions of Articles 14, 19, 27, and 30 of this law.